District of Kentucky. I'm based out of Louisville, and I, along with the Department of Justice, worked on this investigation of LMPD and Louisville Metro. So I'm going to pause for a moment and start things off with some housekeeping matters. If you would like Spanish interpretation, please click on the interpretation button on the bottom bar. It looks like a globe. And for ASL interpretation, you can see our interpreter in the main room here. For closed captioning, you can click the CC icon in the bottom bar. As you know, in March 2023, the Department of Justice issued a report which found that Metro and LMPD engage in a pattern or practice of unconstitutional and unlawful conduct that specifically found that LMPD uses excessive force, conducts unlawful stops, searches, and arrests, unlawfully discriminates against Black people, and violates the rights of people engaged in protected speech critical of policing. We found that Louisville Metro and LMPD both discriminate against people with behavioral health disabilities when they were responding to them in crisis, and we identified deficiencies in LMPD's response to and investigations of domestic violence, sexual assault, and sexual misconduct involving LMPD officers. We determined that these violations arise from problems within LMPD's accountability systems, within their policies, and within their training. After we issued that report, we conducted outreach across Louisville and within LMPD to hear ideas for reform. We received invaluable input, including from many in the Zoom tonight. We're so grateful for the time, your energy, and thoughtfulness as you have poured into this city, into improving this city, our city. At the beginning of this year, we then began negotiations with Louisville Metro and LMPD to address the violations and the deficiencies that we found in our investigation. The negotiations took some time. After many months of negotiations, we did file with the federal court here in Louisville a proposed consent decree, which addressed those violations and deficiencies. This court enforceable agreement includes requirements that Louisville Metro and LMPD revise their policies, their practices, and trainings in areas of use of force, stop searches and arrests, responses to First Amendment protected activity, situations involving behavioral health crisis in sexual assault, domestic violence, and sexual misconduct. It also includes provisions that require Louisville Metro and LMPD to conduct community surveys about LMPD's relationship with the Louisville community and public safety. It requires development of a community engagement program and gives community members the opportunity to comment on Metro and LMPD policies that would be required by this proposed decree. The decree essentially is a roadmap to constitutional policing and public safety services. Every section of the decree includes specific goals called key objectives. These spell out what Louisville Metro and LMPD must achieve to bring about real change. There's 81 key objectives. It's going to guide the implementation process and provide clarity for everyone about Louisville's progress towards reaching the bottom line of constitutional and effective public safety. The United States and Louisville have also signed an agreement in principle that reflects the parties' commitment to work together to promptly create performance review methodologies. And that's for each section of the consent decree. The performance measures will break down the key objectives into specific actions that Louisville Metro and LMPD personnel must take to comply with the consent decree. Once the court reviews and approves the consent decree, the next step is for the parties to select an independent monitor to recommend to the court. The monitor would be an agent of the court, tasked with assessing Louisville Metro's and LMPD's compliance with the decree. The monitor would issue public reports which detail those findings and regularly meet with members of the community to discuss Louisville Metro and LMPD's progress and hear from community perspectives about its interactions with LMPD. Importantly, You, the community, will be a vital part of the monitor selection process. You will have an opportunity to review and provide comment on candidates' applications, and you'll also have an opportunity to hear from and ask questions of the final monitor candidate. And we look forward to hearing from you too as we move forward in this process to get your thoughts regarding whether the consent decree is working and whether you see better, more constitutional and lawful policing in this community. But for now, I'd like to introduce my colleagues so they can tell you more about the specifics of the decree, and then we will turn to answer any questions you post in the chat, which we are following right now. So Maveen, Dave, Haley, would you please walk us through the decree?
Yes, thank you, Jess. My name is Maveen Riaz. I'm a trial attorney with the Civil Rights Division here in DC, and I've been on the team, on this team since the very beginning of our investigation. So thank you again for being with us here tonight. I wanted to start and do a little bit of stage setting for what the decree structure looks like, sort of across each section. So you'll see that every section in the decree is organized into three main buckets of requirements: policies, training, and evaluating the conduct to ensure compliance with policies and trainings through the key objectives that Jess was talking about just a little while ago. So each section has requirements on the changes that LMPD needs to make to their policies, requirements for their trainings. And then the big task is to evaluate whether officers or employees' conduct aligns with those policies and trainings, and whether they're achieving the intended goals of each section that are stated in the decree. I want to start by talking about use of force. Use of force is one of the largest sections in the decree. And like other sections, it has policies, training, and also data requirements. So you'll see that there are requirements governing the overarching rules about when it's appropriate for officers to use force and how and when to use force tools, such as tasers and OC sprays, batons, canines. The decree also has an emphasis on de-escalating encounters so that officers, when safe and feasible, avoid the need to use force, or they lessen the severity of the force they used. The force section also breaks down uses of force into 4 levels when it comes to reporting force. So the more severe the use of force, the higher the level. So, for example, a takedown is a lower level of force than a taser is. And that's lower level force, a use of force than a chokehold is, and so on. So these levels correspond to the reporting and investigation requirements. So the decree has a number of requirements for officers and supervisors and investigators on what to do when there's been a use of force against a member of the public. So it requires every use of force that falls into one of these 4 categories to be documented, to be reported by the officer and reviewed by multiple levels of supervisors to determine whether the force was appropriate. So the more serious the use of force, the more in-depth the investigation and review process. Finally, when it comes to use of force, the decree also requires LMPD to collect, analyze, and report out data on uses of force, both internally and publicly. And the goal here is to identify significant trends and course correct and improve performance across the department when it comes to uses of force. That's use of force in a nutshell in the use of force section of the decree. There are also use of force requirements in the protest and demonstration section of the decree, which I want to touch upon briefly. So more broadly, the protests and demonstration section of the decree includes several policy and training requirements that are geared towards ensuring that officers protect and respect the First Amendment rights of all persons to criticize and protest police conduct and to observe and record police activity. And one key tenet of doing so is having limitations on about when and how they can use force against protesters. And the decree spells this out in detail. It also requires officers to document justifications for their uses of force in their force reports so that supervisors can review that individual basis and the department can review it on a macro department-wide basis. The section also includes requirements about organization and planning, so that Louisville Metro and Louisville Metro Police Department can better manage large-scale events so that the chaos that Louisville experienced in 2020 doesn't happen again. And finally, the protest and demonstration section also prohibits mass arrests and requires each arrest to be supported by probable cause. So that's the protest and demonstrations section in a nutshell. I'm going to turn it over to Dave to talk a little bit more about the stop, search, and arrests requirements more broadly in the decree.
Thank you, Maveen. My name is Dave Cooper. I'm an attorney on our team at the Civil Rights Division. And I, first of all, wanted to talk about the decree's provisions that relate to searches of people's homes. There's a number of requirements of changes to LMPD's practices. In particular, when LMPD applies for a search warrant to search a home, they must state specific, individualized, and accurate facts that establish probable cause for everything that they're going to search or seize. And when officers execute those searches, they must enter homes and conduct searches using safe and lawful tactics. The decree also includes a number of required changes to LMPD's practices in street enforcement. That includes when and how officers stop and frisk people, stop vehicles, search people in cars, and make arrests. Officers will not be permitted to conduct stops, frisks, or searches unless they have a justification that they can explain using specific facts that relate to the individual who is stopped or searched. In order to cite or arrest someone for certain low-level nonviolent offenses like loitering and trespassing, officers will need to explain why a warning or a referral to other Louisville Metro services would be inappropriate or would be insufficient to address the violation. All of these activities must be thoroughly documented with justifications explained in writing by the officer who takes that action, including the facts that led the officer to believe that the action was appropriate. Supervisors are then required to review those reports to make sure that officers are following the law and following policy. And when they find problems, they will be required to take action to address them. There are also requirements in the decree that Louisville enforce the law fairly and impartially, providing equal protection for all people in Louisville. And to ensure it lives up to that requirement, LMPD must analyze its data regarding traffic stops in other areas and take steps to reduce racial disparities in law enforcement. And you will not have to take anyone's word for it. These analyses will be available to the public so the community can see how the police department is doing. These are just the highlights that we're giving you here tonight. There are other requirements that relate to these areas. And so to move on to the next section, I want to turn it over to my colleague, Haley.
Hi, good evening. My name is Haley Van Aram, and I am a trial attorney with the Civil Rights Division based in DC. I'll start with telling you the high level of the provisions in the section regarding the Americans with Disabilities Act. The proposed decree contains requirements regarding Louisville Metro's and LMPD's response to people with behavioral health disabilities. In our findings report, we found that police unnecessarily respond to people in behavioral health crisis when another response, a behavioral health focused response, would be appropriate, and that when police do respond, their response was frequently ineffective and harmful. In the consent decree, we address these issues. The proposed decree requires Louisville Metro to strengthen and expand its non-police deflection program, including dispatching mobile crisis response teams to some behavioral health calls. So the deflection program, which is sometimes also called the Crisis Call Diversion Program, was launched by Louisville Metro government in March 2022, and Louisville Metro has since expanded its hours to be 24/7. Deflection includes a behavioral health specialist handling behavioral health calls that come into the 911 call center, and it also includes mobile crisis response teams responding in person to people in crisis instead of law enforcement to some calls. The consent decree requires Louisville Metro to evaluate the criteria used in the deflection eligibility and eventually expand the calls where deflection can respond. It also requires a timely response of deflection teams and a 24/7 response. It also requires LMPD officers to call deflection under circumstances they respond to that could benefit from behavioral health responders. Louisville Metro will also be making changes within its 911 call center as part of this part of the decree. As I mentioned, there will be behavioral health specialists handling behavioral health calls in the 911 center. In addition, all 911 call takers will receive training regarding behavioral health. There will also be a behavioral health coordination and
Oh, sorry. Looks like Haley.
Go ahead, maybe.
Yeah, it looks like Haley just we just lost Haley. I'll pick up where she left off. I think she was talking about the Behavioral Health Coordination and Oversight Council, and that's good. That's a council that will be composed of stakeholders, and the goal for them is to regularly review incidents and evaluate Louisville Metro's progress towards its goals under the ADA section of the decree. Louisville Metro will also request participation in this council from behavioral health providers, peer support specialists, homelessness service providers, and people with behavioral health disabilities who've had law enforcement contact to make sure that the council is a well-rounded representation of the involved stakeholders. Also, Louisville Metro and LMPD will provide training for officers on how to respond to individuals with behavioral health needs, and will offer specialized training for volunteer officers to become what the decree calls advanced behavioral health response officers. And they'll be the preferred officers that will be tapped to respond on scene when a law enforcement presence is necessary. And LMPD will also continuously assess whether these officers, these advanced behavioral health response officers, are appropriate for that role. I see we have Haley. So Haley, I just wrapped up the requirements of the behavioral health section. I'll keep going with this just in case the internet gets a little bit dicey. So why don't I talk a little bit about the sexual misconduct, sexual assault, and domestic violence sections of the decree as well. So this section of the decree addresses LMPD's on-scene response and investigation of reports of sexual misconduct, sexual assault, and domestic violence. So you'll see the decree breaks down the requirements for each type of report and includes separate sections on what LMPD must do when the reports are against LMPD officers. Some of the decree requirements for these sections include conducting trauma-informed interviews, completing timely reports such as lethality screenings and JC3 reports and strangulation forms, and offering victim support services when they get these reports made. The section also requires LMPD to reestablish its sexual assault response team. SART is what it's called in the decree. And that team will substantively review a sample of LMPD's investigations of these reports, of the reports of sexual assault, domestic violence, and sexual misconduct. And their goal will be to substantively review a sample of those reports to evaluate the quality of LMPD's response and investigations and identify any potential training, policy, or other recommendations that can improve LMPD services. And as part of establishing the SART, LMPD is going to be required to reach out to community stakeholders to create the policies and protocols for how the SART will function in practice. So that's the sexual assault, domestic violence, and sexual misconduct section in a nutshell. I want to also talk a little bit about the community-based public safety section of the decree. So this is the decree includes several opportunities for the community to get involved. But this community-based public safety is one of the biggest. It requires Louisville Metro to create a community engagement program that can be modeled and sort of fit to address the needs of the particular communities they're addressing on a district level, on a neighborhood level, on a department level. So the decree also requires LMPD and Louisville Metro to maintain a safety plan, a public safety plan, that identifies public safety challenges, ways to address those challenges, ways to reduce unnecessary enforcement contact with the police, and ways to reduce unlawful racial disparities. And Louisville Metro will reach out to stakeholders from sort of a wide array of groups in order to develop that public safety plan and include recommendations and thoughts and ideas for what those priorities should be in that plan. In addition, Louisville Metro will maintain and strengthen its non-police outreach teams. Those teams are geared towards responding to situations involving unhoused individuals that do not warrant a law enforcement or behavioral health crisis response. And under the decree, the outreach team is required to be available at least 6 days a week, 8 hours per day, and have the capacity to respond to requests for services by various community stakeholder groups. And it's going to maintain documentation and centralized intake and dispatch information on how they're responding to referrals. So that's a little bit about the community-based public safety section. And really that's a place where we need community involvement, community input, and community engagement. It's going to really be an opportunity for you all to get engaged in how Louisville Metro is engaging with you all. So we hope to have you all involved in that. And I will turn it over now to Dave to talk a little bit about the remaining sections.
Thanks. I want to talk about a few provisions at this point that are intended to lead to changes that will touch all of the different areas that we've already talked about and really affect LMPD across the whole department. First of all, there's a requirement that LMPD develop a hiring program to attract diverse groups of well-qualified individuals. Second, there are provisions that address the subject of officer assistance and support. We know from experience that officers who face their own mental health issues or other personal challenges are less likely to perform their jobs well and more likely to have interactions with the public that result in harm. So the decree requires LMPD to strengthen its support for its own officers through things like counseling services and other ways of providing assistance. Another area that the decree addresses is training. It requires LMPD to revamp its approach to training. Good training for police officers involves more than just an occasional day in a classroom watching a PowerPoint lecture. It involves scenario-based training, role-playing, case studies, other techniques that truly help prepare officers for the situations they're likely to encounter and make sure they understand what is expected of them. We need them to have a deep understanding of what's permitted and what isn't, what their authority as officers empowers them to do, and what the limits of that authority are. LMPD will be required under the decree to adopt these types of training practices, and they will also be required to incorporate the community into their approaches to training. In some cases, by including community members directly in a training. In other cases, by reaching out and seeking input from community members about how their views about how officers should be trained and how officers should approach members of the public. The decree also addresses the area of supervision. It requires LMPD to take a number of steps to strengthen supervision. Supervisors will be required to review officers' reports, review their body camera footage, and ensure that they understand the rules and that they are following them. And supervisors are expected to act when they see problems. Depending on how serious the problem is, that action could be referring an officer for training, more closely monitoring an officer's future activities, or it could mean referring an officer for potential discipline. And finally, accountability. The decree requires changes to LMPD's accountability systems. It will be required to eliminate unnecessary barriers to people who wish to make complaints about officer misconduct, and it will be required to investigate misconduct allegations fully, fairly, and efficiently. And so with that, I think I'm going to turn it back to Jess, who is going to, and we are going to address some of your questions.
Thanks, Dave. We've received a number of questions here just asking about next steps. Things like, when do you anticipate the judge's signature making the decree an order? What happens with the monitor and the request for applicants? How does that work? I'm thinking, Maveen, would you be willing to take that question?
Yes, definitely. So last Thursday, Louisville Metro and our team at the DOJ, we jointly filed this consent decree with the court in the Western District of Kentucky. And now the immediate next step is for the court to review the filing and enter the decree as an order of the court. So that is pending with the judge as of now. Once that occurs, both parties, meaning Louisville Metro and the United States, will put together a request for application package that will solicit applications from sort of anyone who wants to apply to be the monitor in this case. And we will sort of we have a deadline by which that we'll be accepting these applications. And once that deadline expires, we will put the application materials on a public website, and we will conduct a sort of interview process. But before that, we will give the community an opportunity to weigh in on the applications. So this is another opportunity for the community to get involved in this implementation process. We want to hear your thoughts on who we should recommend to the court. The ultimate decision on who the monitor will be rests with the court, but the parties will make a recommendation. They'll say, we've done this extensive review process, we've heard from the community, and we recommend, this person or this team to be the monitor in this case. So aside from being able to comment on the applications, there'll also be a process that will allow the public to basically interview or question the finalists that the parties choose. And that will be sort of after the application process, after the interview process, after we've taken a look at the public feedback and we have our finalists. They will be presented to the community to answer questions. So again, another way for the community to get involved. And like I said, we will then make our decision on who we recommend based on all of that input. And then it will be up to the judge to decide who they will choose to be the monitor in this case.
Thanks, Maveen. We're also receiving a number of questions about administration changes, that there's going to be a change of administration for the presidency in January. How does that potentially affect the consent decree or the process here in Louisville? I don't know, Paul, if you want to introduce yourself and answer.
Sure thing. Hey, everybody. My name's Paul Killebrew, and I work in the Civil Rights Division in DC. So the folks that you're seeing on the screen here, Maveen, Jess, Haley, Dave, me, we're all what they call career people in the Civil Rights Division. I started in the Civil Rights Division in January of 2013. And the folks here started various times over the last 10 to 15 years. So, we work within government, within the Department of Justice, across different administrations. That's our role. Our role is to be the career staff who are consistently there doing this work. And, an interesting thing about consent decrees is that when we submit them to the court and the court enters them as an order, it really becomes the court's order. And we are parties before the court who are there to defend and implement that order. And so it does sort of take it out of the hands a little bit of the sort of back and forth. And part of the reason we use consent decrees is that we anticipate that the changes that are going to be necessary may take some time. And so it's a way to make sure that there is consistency in the approach towards that change across different administrations in the city and the federal government, and that we can just keep on moving these things forward.
Thanks, Paul. I'm reading a couple of questions about civilian oversight. Dave, perhaps you can take this. Do we have any evidence that the Civilian Review and Accountability Board and the Inspector General are meeting their duties as laid out in the bylaws, trying to promote meaningful citizen involvement for police misconduct? And then can you also talk a little bit more about will the Louisville OIG at Harness continue in that role, taking complaints? Will there still be a civilian accountability board?
So thanks for those questions. We basically addressed civilian oversight by taking the law that Louisville Metro has and the system that is in place, and our decree does not change that or does not prevent Louisville Metro from making changes to it. There are provisions that do require LMPD to provide information and access necessary for those civilian oversight bodies to perform their duties. But it is not, those oversight boards, they were not part of our investigation, and they are arms of Louisville Metro that Louisville Metro can change if they choose to. Jess?
Thanks. Another question we're receiving is about the timeline. We've heard a number of times now that the consent decree here talks about accomplishing all of these reform within 5 years. And Maveen, I was wondering if you could discuss or answer the question here, which is that possible?
Yeah, absolutely. Yes, it's possible. But the ball is in Louisville Metro and LMPD's court. The decree is achievable with the staffing and the resources that LMPD has, but it might require some reshuffling or reallocation of resources. And there's provisions in the decree itself that are aimed at freeing up officers' time so that they can work on addressing crimes and helping victims in accordance with the decree's obligations. Also, the decree doesn't just go away automatically after 5 years. The decree requires Louisville Metro and LMPD not only to achieve compliance with each section of the decree, but also requires them to sustain compliance with each section, typically for 2 years. So the goal is not to have Louisville Metro and LMPD get it right at one moment in time. We want to see the changes be durable and embedded into the fabric of the city and the police department, so that they don't go back to the type of behavior that got them here to begin with.
Thanks, Maveen. There's another question about the OIG, specifically paragraph 516. Dave, I'm going to send this one to you. This person wants to know if they deliver a complaint to a Louisville Metro agency outside of LMPD, can they specify that it go to OIG or will it go to LMPD regardless? Talk to us about the complaint process.
So the responsibility for investigating misconduct that can lead, where the investigation can lead to discipline, that lies with LMPD. That's the law that Louisville Metro has in place. There is also the ability of the Inspector General to investigate as well, and that's where that access question is addressed in our decree. So, if you submit a complaint either to LMPD or to another agency, it is first of all the responsibility of LMPD to determine whether there is some misconduct that took place that warrants discipline. The the decree requires that OIG have access to the complaints that LMPD receives. So if you submit a complaint to LMPD, it should go to the OIG as well. And the Civilian Review and Accountability Board, it can then determine whether that is a case that where an investigation by the Inspector General is warranted as well.
All right. Thank you, Dave. I think we're also getting some questions about what will happen if LMPD doesn't comply with the decree or that they violate the decree. So one of the benefits of having a consent decree that's entered by the court is that the court has the power to compel compliance. So that's why it took time to get this decree right, because every provision is going to be something that LMPD is going to be held accountable to, and one that we as the DOJ have the ability to enforce if it's not getting done. So if there's problems with compliance, the monitor will identify it, or we will identify it, and we will work with Louisville to fix that noncompliance. But if for some reason we can't get them to do that, the court can. And so the court will have the ability to bring them in, question them about compliance, and also maybe even find them in contempt if they're not complying with the decree, and impose sanctions if necessary. So that is about what happens when there's issues with compliance. We're also looking through the chat. We're getting a lot of great questions. Let's see.
Another question, Maybeen, I'm seeing here is what will happen if there's a violation of the consent decree?
Yep. I think we lost you for a quick second, Jess. So we talked a little bit about that.
Gotcha.
Yep. Sorry about that. Let me keep going through the chat. Let's see. I'm having some questions about like who the monitor is going to be. Are they going to be somebody from Louisville? Are they going to be somebody nationwide? The goal of the monitor.
Sorry.
Sorry. Oh, I'm sorry. I was muted this whole time and I was talking. I apologize. Was I? Oh, okay. So we were talking a little bit I was just talking about the monitor and who the monitor is going to be. Are they going to be Louisville? Are they going to be somebody coming in from out of town? And the answer to that is we want somebody with a rich law enforcement background, somebody who has project management capability, somebody who has the ability to look at the big picture of a police department, look at data, look at audits. And so that might be somebody from Louisville, but it might also be somebody with sort of national policing expertise. And that's something that the community can weigh in on. You will have the opportunity to review the applications that come in and say, well, this person's a better fit or this person's a better fit based on what your all's thoughts are about what a monitor should look like. And one of the key things for a monitor is also being able to communicate with the community. That's going to be one of their core functions, is really being the eyes and ears of the court, not only in terms of LMPD's compliance, but what is the community demanding? What are their feedback? What's their impression of Louisville Metro? So we really encourage everyone to get involved in the monitor selection process once it kicks off.
Terrific, thanks. Another question, Haley, if you don't mind answering this one. People are asking about the cost. How much is it going to cost the city to implement this consent decree?
Sure, and I apologize for my earlier internet issues. Hopefully that doesn't happen again. And so on the cost issue, Louisville Metro will bear the costs of implementing and monitoring the consent decree. The monitor's budget will be capped at $1.475 million per year, which is comparable to the cost of monitoring under similar consent decrees in other cities. This would constitute approximately 0.6% of the LMPD budget, which is about $240 million for the current fiscal year, and approximately 0.1% of Louisville Metro's total budget, which is about $1.1 billion. We've seen some outrageous claims about the cost of consent decrees and reform. These claims are overblown. The kinds of costs that people attribute to consent decrees are in actuality often the cost of running a police department lawfully. Modern police departments must have functional internal affairs units, training academies, and records management systems. And at the outset of the reform process, the departments that we have worked with typically lack some of those essential components of policing. So the departments need to make those investments, and that's the cost of doing business, not the cost of consent decree.
Thanks. How about this question will make it for Maveen. How can we expect fair and unbiased investigations of LMPD by LMPD?
Yeah, absolutely. There's a couple ways. One is we as the DOJ and the monitor will get to probe these investigations and evaluate them on a qualitative basis about whether they were done right. So that includes the misconduct investigations that are going to be occurring. The misconduct section will have or does have a lot of requirements about what the fair investigations that LMPD conducts by pulling a random sample, looking at the interviews conducted, looking at the body-worn camera, looking at whatever documentation is there or is not there to evaluate whether these investigations were meaningful, and just like us as at the DOJ, and provide ways for Louisville to get their investigations up to mark. So, as with anything else, compliance assessments from the monitor, so these reviews by the monitor and the police department will be made public, and that information will be there for the community to also look at in terms of where the successes are, where there's more work to be done. So the long and short of it is you don't have to trust anyone in this process. You can sort of evaluate this. You want people to remain engaged and look at the data critically and scrutinize the data. So that we're really holding. I'm
glad you asked that, or you stated that. We're looking to see how is this consent decree being successful at the goal of maintaining constitutional policing and really establishing the proper public safety measures that need to be in the city of Louisville. Paul, would you mind discussing some of the successes that have occurred over the years in other cities with consent decrees?
Yeah, sure thing. The law that we're enforcing here, Congress passed it in 1994. So we recently had the 30th anniversary of this law that we use for a case like this. So in 30 years of doing this kind of work, we've had consent decrees in other cities as well. And we've had a chance to see what they can really accomplish and to learn from the things that have happened in other places. And so cities that have consent decrees, Louisville itself can learn from them, not only the police department and the city government, but, folks who live in Louisville are just interested in this process. Our website has the consent decrees from all the other cities and a bunch of information about how they have been successful, what they've been able to accomplish. And you can reach out to the email address that's been put into the chat and that is in our backgrounds. If you want to set up time to talk more about all of this, just to get familiar with how our work goes. But just to give you some examples of how these consent decrees have worked, we have a consent decree in Seattle about the Seattle Police Department. And we had an issue there about police officers using force when people were in some kind of behavioral health crisis. And as a result of the consent decree, force is used in only 2% of those kinds of encounters now. And most of the force that's used, 65% of the force that's used by Seattle is low-level force, meaning often officers just using their hands rather than something like a taser or a firearm. In Portland, there's been a significant reduction in the use of tasers. And when officers are using their tasers, they're using their tasers in compliance with the law and national best practices. In Baltimore, we investigated that police department after the death of Freddie Gray during a police transport. And as a result of the consent decree there was a complete overhauling of the fleet of transport vehicles. And so there were, out of 16,000 transports, there were just 11 reported injuries after implementation of the consent decree, remedies related to that. And we've seen use of force drop in Baltimore since 2017 by 62%. In the city of Albuquerque, New Mexico, we have a consent decree. And during the life of that decree, the city established a whole new agency that is basically like a third first responder. There's police, there's fire, and this new agency, Albuquerque Community Safety. And it responds to calls where there are people who are having a behavioral health issue, but they don't need a police response. That new agency is now taking 5% of the call volume from the police department. So 5% of the things that the officers used to do now go to this new agency, and no police need to respond at all, which frees up the police officers to deal with violent crime and other public safety threats, and gets people the kinds of services they need.
Thanks, Paul. It's a lot of great work that's been done by these past decrees, but one thing we're hearing a lot here in Louisville is that this decree is historic in nature. It's different than what happened in the past. Dave, I'm wondering if you could answer that, explain that a little bit more. Is this a historic decree? What's the difference, if anything?
Absolutely. So there's a number of things that I'd like to point to. First of all, the way that we break out specific goals in each section of the decree, what we call them key objectives that articulate exactly what Louisville Metro and LMPD have to achieve in order to bring about real change. These key objectives will guide the whole implementation process. They will provide clarity for everyone, both inside Louisville Metro and outside, about what Louisville's progress toward reaching the bottom line constitutional effect of public safety looks like. Second, Louisville Metro and LMPD, in partnership with the Justice Department, will break down these key objectives into dozens of specific metrics that the independent monitor will then use to evaluate their compliance with the decree. Change doesn't happen in the abstract. Policies are important. Training is important. But the changes must be seen and felt in the way that officers do their jobs on a day-to-day basis, how they interact with people, the sort of professionalism they bring to every call. And that's what these metrics will look at. They're going to look at the day in and day out of what officers are doing. And all of that data that the monitor gathers and uses to make these assessments will be public. So the community doesn't have to take the monitor's word for it. You don't have to take our word for it. You don't have to take LMPD's word for it. You will have access to that data yourselves. Finally, Louisville Metro and LMPD have committed to fully implementing this decree in 5 years. The ball is in their court to make the changes they need to make in order to live up to this commitment. And to evaluate whether they're able to live up to this commitment, the decree includes an inflection point at that 5-year mark, where we at the Justice Department will take a hard look at the evidence and see whether the city is on track. If they've met their commitments, the decree will end. If they haven't, the decree gives DOJ the tools that we need to hold Louisville accountable to its commitments and push reform forward. And I want to briefly, if I could, just add about that 5-year inflection point. When we make that assessment, we'll be taking many sources of information into account. One of them will be community's views. And in fact, throughout the process of the decree, we will be taking into account the community's views as we hold Louisville to its commitments, because our role of ensuring their compliance that won't begin at 5 years. That will continue throughout, and your contributions as community members will be an important part of that.
Thanks, Dave. This one's for you, Haley. Someone wants to know, will members of the community be involved in the training requirements in the consent decree?
Why don't I take this one? Yeah, I want to take this one. So yes, the community will be involved. There's a couple different ways to get involved in the training process. Louisville Metro will be creating a training plan, and that will sort of identify what's coming up based on the needs of the department. And in developing that training plan, Louisville Metro will consult with the community, get their feedback on the topics and the areas that should be on tap for the next year. Another way to get involved is Louisville Metro will be reaching into the community to come and help deliver trainings. When we're talking about behavioral health issues, when we're talking about things that are community engagement, they'll be pulling in people from the community to help deliver that, so that the officers are getting a sort of well-rounded perspective of the information that they're soaking in. So yes, just another opportunity for the community to get involved in training and policies. For policies, I'll say as well, policies will be posted in draft form so that, again, the community can weigh in on the content of the policies. That is the first big bucket of activity that Louisville Metro will be doing, revising their policies to comply with the requirements of the consent decree. And as part of that revision process, they will post these policies, the draft policies, and the community will have the ability to weigh in, provide feedback, and Louisville Metro will be required to incorporate that feedback when appropriate. So again, for policies and training, absolutely, you'll be able to get involved. Jess, I'll turn it back to you.
Yeah, there's also a number of questions just about trust. How can we trust that LMPD is going to be doing what they say they do, are going to do, and that they can actually engage in the investigations?
Yeah, thanks for that. It's a completely fair question. We conducted an investigation, released a report in 2023 that found a pattern or practice of violations of the Constitution and federal law. We found issues with how investigations were being, LMPD's failure to take appropriate action when violations of the law occurred. And here we are now with this consent decree that sets them up with a lot of responsibility to look into these things themselves. And so why would we think it would be any better now? But that is what this whole process is meant to build within LMPD. And it's not a situation where we just tell them, please do it, and we hope it works out. This is something where we are going to be, and the monitor is going to be evaluating their capacity to do this. And this decree won't come to an end until they can do that reliably. Every time that something happens, they need to look into it seriously. And if there was a problem, they need to address it. I understand why folks have trepidation about that whole premise, but the consent decree is not going to last forever. They're not meant to last forever. And they're meant to leave Louisville with a structure and a system that you can trust and rely on, so that you don't have a recurrence of the pattern or practice. They have to have that kind of credibility. They have to have that capacity, and they need to be transparent throughout that you can see it yourself.
Thanks. There's a question here about why DOJ decided to go for the consent decree, why that's what we negotiated, as opposed to a memorandum of understanding. If LMPD has already taken steps that the Department of Justice is asking them to take in order to enforce and create constitutional policing in the city of Louisville, why is a consent decree necessary?
Yes, definitely. So the Department of Justice has been working on these practice cases across the country for the last 30 years. And we've taken a look hard at the work that the cities are doing. And in our experience, consent decrees are the best way to secure durable, sustainable change. So we talked a little bit about administration changes and what happens when every 4 years or every 6 years there's a new person in town on either the the United States side or on the Louisville Metro side. And the consent decree, as I mentioned earlier, is a court enforceable document. It gets entered as a order of the court, and it does not depend on a particular person or persons enforcing it. The rules are the rules once it's entered in, and it doesn't matter who's enforcing it. That sort of will be stable and sort of set in stone once it's ordered as a decree. So to preserve the sustainability and the durability of this, the consent decree was the best option. And again, that's sort of why we've spent a lot of time and energy making sure that the provisions are precise and they are comprehensive so that there's clarity from both sides going into this about what's required and what the path forward for the next five and some years will be.
We're also getting questions, Dave, I'll throw this to you, about some comments that the mayor made during the press conference last week. The mayor mentioned that it was possible for them to get some of the requirements of the decree lifted as the years went along. The requirements didn't have to go all the way to the 5-year mark. Could you explain that a little bit more for folks? Is that true? And if so, what does that mean?
Well, if Louisville can show that it's in compliance with with one section of the decree, then they can move forward with potentially partially terminating that. So we described all of the subject areas that the decree covers earlier. So as an example, if all of the provisions relating to force are in compliance, so it's not a situation where one or two things can be picked off and separated out. It's also I also want to mention that Louisville has to show not only that they've reached compliance, but also that they've sustained compliance, that the systems they have in place are durable and will continue.
To a close of our hour here, so I want to encourage everyone to stay engaged, stay involved, reach out with any questions, comments, concerns you have. As you've seen over our heads in the Zoom this evening, community.louisville@usdoj.gov is our community email account, and we can all respond via there. You're also more than welcome to contact us via telephone. Our number is 1-844-920-1460. Believe we're putting that in the chat for you here too. But again, sincerely appreciate all of your input, and we look forward to continuing this conversation. Thank you all.